Hello, everyone. Welcome INTA members for this capsule keynote session. This segment, we are having a very interesting guest with us, Dr. Tarek Hajjiri, who is the Senior Vice President Legal and the IP Commissioner of the Dubai International Financial Center, DIFC. So please join us for this discussion that we have over the new DIFC IP law that has been issued. We just wanted to discuss and to our members of the INTA community about the exciting new DIFC IP law that has been issued, which covers basically a combination of all IP rights under one law. But before we enter into that, I wanted to just have an understanding a little bit for our audience of the DIFC itself as a financial free zone. What makes it unique in our region?
Actually, thank you very much for having me today with you and with the distinguished audience. I'm always proud to be part of this community for the IP community. For the people who knows me, I am an IP practitioner. So this is something that I come, as from the same background, and I'm very passionate to IP. For the DIFC, it's a financial free zone. For the UAE, it's a civil law system, and we have within the UAE a common law system which were found in financial free zones, which is the federal financial free zones, and where it applies. It's a common law system within a civil law system. So, and that's actually what takes me to give a brief of on the uniqueness of the legal system within the DIFC. That is the ecosystem of the DIFC is a very unique and high standard as per the international standards. For the intellectual property or the uniqueness of the DIFC for the IP is that the law itself came as a very important element to complement the legal system within the DIFC. For the people who knows, we have our own judicial system. We have our own courts that it is an English-speaking and English law system. We have the legislative framework where it is all based also on the common law system. So the IP law came as an additional element of strength that adds to the DIFC. So we have the ecosystem that is very important for the economic growth and prosperity. As you know, the relationship between innovation and IP, it's all about IP laws. So when it came the IP law within the DIFC, it came after long years of study that that really we need it as a cornerstone for economic growth and prosperity.
Yeah. That's very interesting because we, in our region, we're all used to being practicing in a civil law country.
Yes.
So this is a very interesting development because it's the first time that we actually have an IP law, yes, in the DIFC, but that actually has the common law concept. So it does help with the harmonization of international community, international laws as well.
True.
And one of the things that we've had some people ask the question, brand owners really want to know. So you have a DIFC IP law that's basically relevant to the DIFC, to companies, entities in the DIFC. And you have the federal IP laws, which basically is related to everything else in the UAE. So if I file for a trademark in the UAE, as a brand owner, do I now need to file separately in the DIFC as well?
No, actually, for the DIFC IP law, it recognized the federal law. So we complement each other. So we came, or the DIFC IP law came as an additional protection and strength in the UAE legal system. It is very much aligned and very, works properly and in harmony with the UAE federal system. We recognize all the IP registered rights or IP rights So you don't have to register your rights within the DIFC in order to be protected. We recognized all IP rights. So it came actually without any kind of burden on the IP rights owners. Like, for trademark owners, it's fully protected within the DIFC. It's fully enforced, and with even very minimal cost. It's actually, when you file a complaint, you only just need to pay for the fees, which is very minimal. So there is no conflict. There is no kind of extra burden. It works in harmony with the federal system. And it actually adds to the protection. And let me go back a little bit with the ecosystem, to be honest. We all know that IP protection comes most of the time from the laws, right? But some of it also it comes from contracts, where you have your ideas, or you have some of, let's say, transfer of technology. So you have also the contract really is very important. The IP ecosystem, or the legal ecosystem within the DIFC, it provides a very friendly system to the IP owners, from protection or like registration. We recognize the UAE federal system, of course, the federal registration, and then you come to the protection. We provide really very efficient protective system within the DIFC. Exploitation, so it really helps in exploiting also your IP rights, whether it's transfer of technology or like licensing. And then you have the enforcement, and then you have the dispute settlement. So this chain of, let's say, the legal system, or the type of protection, it works in a very efficient way, hand in hand with the company's laws, with contract laws, with all types of, let's say, or with the legal framework, in order to fulfill the needs of the IP owners.
Very interesting. So it's an ensuite, just a continuation and complementing the already existing laws of the DIFC.
Correct.
Such as the company's law and everything else.
Without any burden.
Yes, that's what we want to hear.
Exactly.
Without any burden. That's too good to be true. That's amazing in terms of the harmonization that was involved to that. In terms of, when we were looking at the law, there's been some recent introduction. I mean, when I say recent, meaning that it wasn't explicitly in the UAE federal laws, in the IP, in the trademark section particularly, but there has been some interesting concepts introduced in the DIFC IP law, especially for trademarks, such as criteria for well-known trademarks, also criteria so what can be considered as a fair use in trademark. That's a novelty for us in our region. So that's really exciting that it does cover these elements.
That's true. To be honest, the IP law, or the DIFC IP law, provided a very clear criteria. Even in most of the legal or in other jurisdictions, they have provided protection for well-known marks, but sometimes there is kind of ambiguity about that. So we were very keen to have the IP owners, or the system, or the legal system, to be very clear with regard to protection of the well-known marks. Like, when you can consider that a mark is a well-known, and even for the fair use, even when your use is a fair use, when you are infringing other people's rights, when you are not. So we were very keen to have many things that it's not about like missing, but actually required clarity. We were very keen to provide such clarity.
Yeah, no, absolutely. Because when we were practicing, there was always a topic of comparing advertising in terms of trademark use, and then we were really happy to find it addressed.
That's true.
Explicitly. So these are, as a trademark practitioner, we're really excited to have these concepts explicitly referenced in a law in the UAE.
That is true. As well. And it helps me as a commissioner when I actually want to issue a directive, like, if this brand is a well-known, because this is a question that I'm always asked, like, not every brand is protected, globally, but there are so many brands when actually the fame, or the, let's say, the parameters, is it met within our region? Because, as you know, well-known brand in the jurisdiction might not be in other jurisdiction. But further to this, I may also need to add, even trade secrets. Like that was amazing. Also addition.
That's a novel. That's a new one.
Exactly to the DIFC IP law. So I hope that for all practitioners, for the IP right owners, that to go through the law itself. I'm more than happy even to answer any question by email if they wish. And this is something that we were keen to have it a very a high standard, it's international standard law that will meet our vision and our rulers' vision in this region. Because innovation is mainly built on how much your IP rights, research and developments, everything, all investments. If your IP rights are protected, then you are safe. So the first thing that you conduct as a due diligence is that you look at the IP rights or IP laws in that jurisdiction, and then you decide, to what extent you are going to be investing.
Interesting. And one of the elements that brand owners, I think, will be really happy about is the DI. Now there is an administrative body, and you are appointed with a highly coveted role as the IP commissioner. And we've noticed, obviously, in our region, we've noticed the high administrative penalties, quite hefty fines for our region, especially in a region where we're used to having nominal penalties awarded. And that is something that is a very, very interesting development to give this type of penalties on an administrative level. So this is definitely something that is very new and exciting. And also another point, which is appointing IP experts as well on an administrative level. So tell us a little bit about, I know that with the regulations issued, you are accepting complaints. So if you can tell us a little bit about the complaints without telling us further details.
Of course, like I have been receiving a few complaints, for mainly kind of trademark infringements. As part of my role is to receive complaints and, of course, to issue directives based on it to settle these complaints. So in addition to receiving these complaints and, of course, investigating, conducting inspection, communicating with the parties, so I try, or the Commissioner's Office try to implement a very efficient system, procedures that is binding for me as well as the others, like the 10 days, which is like the period that I have to act, I have to really notify, so it's not actually a loose system that I just put, the complaint on, kind of, okay, I will look at it. No, I'm actually responsible and liable that to issue and to solve these issue, matters as urgent as possible, because this relates to the, people's interests. So we have to do that. Sometimes, and this is something that when we were drafting the law and the regs, you might need some additional, expertise, and that you might feel that it will make you kind of comfortable with issuing your directive. So we created something which is a register for experts, and this is, of course, it's open for everyone to, within, of course, element criteria, to register as an expert. Where I feel that any kind of expertise is needed, then I communicate with the agreement, of course, the parties, so to obtain such experts report. The other thing is for the efficiency of the system or the protection, we also implemented I'm not going to say like harsh, but also a very efficient actually penalty and fines, administrative, fines that we make sure that the infringer does not really repeat such infringement. And it varies when it's, of course, in addition to the traditional inspection like what we do, and seizure and confiscation, destruction, it reaches to other fines, which is from $4,000 to $50,000 or $40,000. And in case of repetition, these fines actually are doubled. And a suspension of the trade license. In case of repetition, I can request the registrar to revoke the trade license. So there's a system where we make sure that the parties or the IP owners' rights are protected efficiently, and that we try to prevent repetition when possible.
Yes.
Because as you know, like most infringers, and I come from the same industry, like, as an IP lawyer, we noticed that infringers, they repeat. They are actually, they don't really feel that they are threatened. And that's why we looked at it, that we may revoke the trade license, we double the fine. And of course, this is something that for them, you are kind of, it's a big threat for them.
Yes, absolutely. Because then if there doesn't have teeth to it in terms of deterrent factors, then there's no point everything, of even creating any system in place without that. So that was a very interesting point. And another as well, I mean, we have traditionally conflicts between a trademark and trade names.
Yes.
That is an ever-going. Yes. So you solved that. Thank you very much.
We solved that.
For that.
Yeah.
And as a practitioner, it's and for our client, it's been very difficult. So then you actually now as the IP commissioner have the power to
issue directives, definitely. And this is something that was kind of a headache for us. And the good thing, and this is something that part of also my role as IP commissioner, is that I work very closely with the local and federal government bodies to ensure that a proper system or administrative system is in place. Now we signed also an MOU with the Ministry of Economy, and they are very supportive to us. And I must thank His Excellency the Minister for his support, and of course the Deputy Minister and all the team for providing such amazing support to us in the DIFC when we started the establishment of course, because we started from scratch. We have to be connected to the system to make sure that we have a connection to the data that they have. It's actually something integration that would save us also time and will fulfill the needs of our clients.
When we usually have enforcement actions, timeline is extremely important. And you've mentioned the 10-day process.
Yes.
So basically the regulations that were issued in July this year, 10 business days seems to be like the magic number for everything. Yeah. So you have 10 business days to review, and the respondent has 10 business days to respond. Even the expert have 10 business days to prepare a report, which I think it sets the tone on the intention to have an efficient, timely enforcement matter that does not drag. Obviously, there is a little, there's a possibility for exceptions in certain circumstances subject to your assessment. But we've thought that this is really important to have this process, tied to a certain timeline.
Yes, because that's something, 10 days might actually be a long period of time for the person or for the client who is keen to protect their rights, right? Yes. But we were trying to kind of hold the stick like from the middle where we don't rush things. And in case of necessity, I can extend that period, but it has for a legitimate reason. Like it's not, it shouldn't be a reason for delaying the process and for the justice, because, sometimes you really need to act very in a quick manner. And in some cases, I have also the power not to notify parties, when I receive some kind of a complaint and I need to do some inspection. So for the sake of, justice, sometimes I need to do a report and then I notify. So the law and the regs are very flexible, very efficient when implemented in a way which is, as per the international practice. So, I come from, as an IP practitioner, so I was, the inside things that, that sometimes really, you feel that I wish if, the wish list of any IP practitioner, I wish if, let's say we amend the law, I wish if we do this, so all this wish list, we were able, thank God, is to implement as much as possible in the law and regs. And I really hope and we are open for all IP practitioners who test and examine, these laws, if they feel that there is a room for enhancement and for, because it's not, this is a man-made, piece of law. So it's not complete. It's not actually, and there is always room for enhancement. We are open, to receive such comments, and we, at the end of the day, we work together for the protection, of course, of IP rights. And as we just said, when you protect IP rights, you protect innovation, you protect economic growth, your investment, because at the end of the day, it all, these all elements are required to just grow our economy, for job creation, for SMEs, for, it's all
connected.
It's all connected.
Yes, yes.
You know what I'm saying? Like, entrepreneurs, it's all built on an innovative idea where it is also protected as in the IP laws. You talk about SMEs, you talk even about family businesses, what we call it, like, diversification of doing business. You have a traditional way of doing business, and then you think of, but I need to think out of the box, and I need to do some other business that might be actually built on innovative idea, or let's say a patent or application or copyright or whatever. So all this, the source of protection is IP rights or IP laws. So that's what we really are keen, and we hope that we reach to provide some kind of certainty and some kind of clarity for the users, as we call them, for the IP laws, whether innovators or investors or licensees or licensors, so this is all, the bread and butter for them.
Of course.
Which is the IP law.
And you volunteered to have a wish list, that we can send a
yes.
wish list for the things that we would like. I'm sure a lot of members from our INTA community would probably take your offer on that and interact, because the way this is set up is that this is not static. This is it's a back and forth with all stakeholders and everyone involved, and you want to hear everyone's opinions. You want to see from both sides, and it's a very exciting time to be an IP owner, to be practicing IP in our region.
True.
And we can stay for as long as we can in terms of discussing all the aspects of this law, but I think we are a little bit tight on time, unfortunately, and we really wanted to continue our discussions, but we had really good insights from you, Dr. Tarek. Thank you very much for joining us.
And on behalf of INTA, thanks a lot.
On behalf of INTA, we'd like to thank you very much for your time.
Thank you very much. Pleasure.